Learning objectives. What is sexual harassment? Who can be a victim? What is meant by unwelcome? Sexual harassment in the workplace can be categorized into two groups. Steps to deter sexual harassment, suggestions, privacy, internal committee, filing a complaint process, settlement and punishment, inquiry report. What is sexual harassment? Sexual harassment is unwelcome sexual advances, requests for sexual favors, and or other verbal, visual, or physical conduct of asexual nature, where submissions to or rejection of such conduct is made either explicitly or implicitly in a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as a basis for employment decisions that affecting that individual. Such conduct has the purpose of or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. Who can be a victim? Sexual harassment in the workplace. Anyone, male or female, can be a victim of sexual harassment. The victim and the harasser can be a woman, man, and they can even be the same sex. The victim can be of any age group, marital status, race, or religion. What is meant by unwelcome? Any conduct or behavior is unwelcome if the recipient does not consent to it, regards it as offensive. Even if the victim does not complain, it doesn't necessarily imply that the conduct is welcome. Some comments and or advances are blatant and crude and are inherently offensive. These will almost always be deemed as unwelcome. Sexual harassment in the workplace can be categorized into two groups. Quid pro quo. Quid pro quo means this for that, an exchange of one thing for another. Quid pro quo sexual harassment takes place if sexual favors are asked in exchange for any kind of special treatment on the job. An employee threatens an associate if he or she does not consent to such sexual advances or favors. Hostile environment. Speech or conduct of a sexual nature takes place and is seen as offensive. Intimidating, harassing conduct that is directed at an individual or a group of individuals takes place. Steps to deter sexual harassment. Number one, do not ignore it. Number two, do not accept the behavior. Number three, report the incident. Number four, any associate may file complaints. And number five, be supportive to the victim of sexual harassment. Suggestions. No harassment policy. It is a declaration to prevent, prohibit, or eradicate sexual harassment. An explanation of penalties with a detailed outline of the grievance handling procedures. It should include a provision to keep all sexual harassment complaints and procedures confidential and time bound. Sexual Harassment of Women at the Workplace Act, POSH Act, applicable at every organization who has more than 10 employees. An internal complaints committee, that's the ICC, at least a 5-member committee at all workplaces employing 10 or more workers. Trainings should be conducted, such as gender sensitivity programs and sexual harassment awareness programs. Privacy. A lot of cases go unreported, and the acts are perpetrated because of the feelings of shame and the negative publicity that the victim might receive, and the professional and social impact it might have on the victim. At KloudLearn, we assure you that the highest level of confidentiality will be maintained. Alleging defamation of character or invasion of privacy should never be a concern for any victim. Internal Committee. The constituents of the internal committee will be a presiding officer who is a senior woman, 2 members committed to the cause of women experience in the workplace, 1 member from an NGO or other women's organization with issues relating to sexual harassment. Filing a complaint process. Report the incidents, a maximum of 3 warnings. The complaint will be passed on to the ICC. The, the person who is convicted of sexually harassing the victim will be notified. He or she should give a statement within 10 days. If the respondents agree, there will be a settlement or punishment, and action will be taken within 60 days. If the harasser denies allegations, there will be an inquiry for a period of 90 days, after which a findings and recommendation report will be submitted back to the ICC. Settlement or punishment. Complaint settlement through conciliation. At the request of the aggrieved women, take steps to settle the matter between her and the respondents through conciliation before making an inquiry. Through no monetary settlement should be considered. Post-settlement ICC or LCC shall record the settlement. Send the same to the employer or the district officer to take actions as specified in the recommendation. Committee shall also provide the copies of the recorded statements to the aggrieved women and the respondents. Where a settlement has arrived, no further inquiry shall be made by the committee. Settlement or punishment. Inquiry into complaint. In case the respondent is an employee, the committee shall proceed in accordance with the service rules. Where not available or applicable, shall forward the complaint to the police under 509 of the Penal Code and relevant provisions within 7 days, if prima facie case exists. Also, if the complaint informs the committee that any terms or conditions of the settlement have not been complied with, then the committee shall proceed to make an inquiry or forward the complaint to the police. If both are employees, the opportunity to be heard shall be given equally. Notwithstanding, anything contained in the section 509 of the Penal Code may direct the respondents to pay sums as it may be appropriate to the aggrieved women having regard to section 15. During the pendency of an inquiry, the committee may recommend a transfer to the aggrieved women or the respondent to a new workplace, grant leave to the aggrieved up to a period of 3 months, which shall be in addition to the leave entitled to her, grant any other relief as may be prescribed. Employer shall implement upon the recommendation and send a report to the committee. Inquiry report. Within 10 days of completion of the inquiry, the committee shall provide a report to the employer or district officer as the case may be and should be available to the concerned parties. If the committee arrives at the conclusion that the allegation has not been proved, it shall be recommended to take no action. A. If the respondent has proven guilty, take action in accordance with the provisions of the service rules applicable, where no such rules have been made in such manner as prescribed. To deduct from the salary or wages or direct such sum as it may consider appropriate to be paid or aggrieved or her legal heirs in accordance with section 15. The concerned authority shall act upon the recommendation within 60 days of its receipt. B. If allegation proved to be wrong, if a false complaint made or any forged documents being procured, then the committee may recommend to take action as per the service rules or as otherwise prescribed. But if the complaint is unable to provide an adequate proof, then no action is to be taken. The malicious intent shall be established after an inquiry in accordance that has been made with the prescribed procedure. Committees arrive at conclusions that during inquiry false evidence have been produced, then it may recommend action against the witness as per the service rule or prescribed section 15. Key takeaways. Sexual harassment is unwelcome. Sexual advances, requests for sexual favors, and or other verbal, visual, or physical conduct of a sexual nature. Anyone, male or female, can be a victim of sexual harassment. The victim and the harasser can be a woman or a man, and they can be the same sex. The victim can be of any age group, marital status, race, or religion. Any conduct or behavior is unwelcome if the recipient does not consent to it and regards it as offensive. No harassment policy. Sexual harassment of women at the workplace and training employees about sexual harassment awareness helps the organization in eradicating sexual harassment.